While joining Seyfarth's webinar, Whistleblower Laws to Combat COVID-19 Insurance Fraud Schemes, all participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to John Bronstein. John, you may begin.
Thanks, Dave. Hi, I wanted to introduce you to today's panel. My name is John Bronstein. I'm a partner in the litigation department in Seyfarth's San Francisco office. My background is commercial litigation, healthcare, insurance, and employee benefits, with a large focus on healthcare fraud and provider billing litigation and reimbursement disputes. Also with us today, I have the pleasure of being joined by my colleague, Kathy Josephson. She's a partner in our Chicago office, also in our litigation department. And Kathy has extensive expertise advising and representing insurance companies in anti-fraud investigations and litigations, including the whistleblower statutes that we'll be discussing today. Also have the pleasure of working today with my colleague, Brad Perkins, partner in our San Francisco office in our labor and employment department. Brad has substantial expertise advising and representing health plans and ERISA and employee benefit plans in investigations and litigation, including healthcare fraud and provider billing litigation and the whistleblower statutes we're talking about today. With that, I will turn it over to Brad to go over today's agenda.
Great, thanks, John, and thanks to everyone for joining today. Some of you may have been there for our presentation that we gave last month on strategies that payers can use to combat COVID fraud, and today we're going to dig a little more deeply into one of the strategies we discussed, which is using these state whistleblower laws to bring litigation against fraudsters. So John's going to start us off by discussing, the playing field today in the COVID-19 environment and why it has created such a ripe environment for fraud. And then Kathy is going to discuss more specifically the state whistleblower laws that we'll be discussing in depth. And then we'll both discuss the purpose behind these laws and who can be sued for what and how much. Then I'm going to discuss some unique issues for self-insured ERISA plans, and John's going to wrap us up with a discussion of procedural considerations that come up in most of these investigations and litigations. And so with that, I'm going to pass it off to Kathy. Thank you. I'm sorry, to John.
Thank you, Brad. Okay, this first slide, COVID-19 is a ripe and breeding ground for fraud. The point that we want to make on this slide is really what we're talking about here is money and opportunity and scale. And, this perfect storm or, confluence of factors all coming together has really made COVID-19, fertile area for potential fraud and fraudsters. First, let's start with the money. New government programs and economic stimulus have pumped trillions of dollars into widespread circulation and have created an unprecedented cash grab. We'll talk about some of these government programs in a little more detail in a moment. But I think as we all saw early on, right, one of the challenges with the the government response at both the state and federal level is there's a lack of sufficient pre-screening and quality controls. These new laws are vague, they're uncertain, never been tested, and the goal was really to pump money into the system as fast as possible, right? And given this, getting the money out fast was more important, it seemed, than getting it out accurately. And in an uncertain, vague, fast-moving environment, it can lead, and in fact did lead, to confusion in the early administration of these government programs. In terms of opportunity, right? People are stressed, and they're scared, and they're vulnerable. This pandemic has created, personal and professional, hardships to people and business. If your business is shut down to a lockdown order, if your kids are at home for schooling and you can't go to work, if you've lost your job, if you're at fear of losing your job, if you've had a pay cut, if you have to try to take care of elderly family members, if you're trying to figure out how you're going to go see your family members, people are under a lot of stress. And certainly we've seen the hardships, economically to business, and not just by COVID-19. Unfortunately, we've seen, other factors and considerations, over the course of the last 6 months that have, made 2020 particularly challenging and COVID-19 a very difficult environment. And unfortunately, right, when you're stressed or financially, strained, that is when, you might engage in conduct or become more susceptible, right, to being a victim of fraud, right? As a victim, that's when, perhaps you might make a mistake as a victim and, be susceptible to fraud scams and fraud schemes. And, there's also a tremendous opportunity for would-be fraudsters to take advantage of that stress, scaredness and vulnerability. Scale. Another piece of COVID-19 is the fact that this is truly a global pandemic. It's impacting everyone everywhere. So, it's not a regional or local fraud opportunity. This is a worldwide opportunity for fraud schemes. So ultimately, right, all these factors, right, money, opportunity, and scale, you really have a tremendous opportunity to exploit these uncertain, confusing new laws and programs with trillions of dollars that are available for the claimants. Okay, this slide, right? COVID-19 U.S. government monetary response. I alluded to this a little bit in the last slide, but just wanted to put up here on the board for a moment, some of the major pieces of legislation that have been passed, over the past 6 months in response to COVID. Certainly this is legislation at the federal level. Obviously, you've got the Coronavirus Preparedness and Response Act, got the Families First Coronavirus Response Act, the Coronavirus Aid, Relief, and Economic Security Act, often referred to as the CARES Act. And then last there on at least for this slide, you've got the Paycheck Protection Program and Healthcare Enforcement Act. You often hear of the Paycheck Protection Program as, PPP. So, a couple of points to make on this slide. First of which is, if you're a business and you've applied, to the government for, state funds or in this case, federal funds, you make certain implied certifications, and that you are in fact eligible for the money. And if for any reason you're not, right, that could expose you to False Claims Act liability at either the state or federal level. And the other point I really wanted to make here is that a lot of these programs, right, or a lot of the money within these programs is directed to, COVID-19 diagnosis, testing, and treatment. And in many cases, right, the money is intended, right, to provide mandatory, requires, right, the insurers or other payers, right, like ERISA welfare benefit plans, to provide mandatory coverage for, testing and treatment of COVID-19, often with no co-pays, no co-insurance, no deductibles, right, and often, limiting the amount of control or utilization review that the insurers and the healthcare plans can do. And that, we would submit is a formula and an opportunity for potential fraud. Next slide, please. All right. Wanted to talk a little bit about some of the specific COVID-19 fraud schemes that we've seen. And given the statutes that we're going to talk about today, we're going to focus, largely on health, auto, workers' compensation, issues that affect those insurers. But before I dive into the COVID-19 specifically, just, conceptually, let's talk about, healthcare billing fraud, the sort of the classic schemes and scams that insurers and other payers like health plans see. First and foremost, right, is fraudulent billing for services not rendered. And in its classic form, right, what I mean is non-existent services, like services that did not occur that are being billed to insurers for reimbursement. Just to give you an example, we had a case a number of years ago where there was a surgeon who billed us who billed the client for performing surgeries in Southern California, 6 of them on a Saturday afternoon in June. It looked a little suspicious. An investigation was undertaken, and it turned out that healthcare professional was actually on the East Coast, not in Southern California, on the Saturday afternoon in question. Suffice it to say those services, never took place. That's billing for service, for non-existent services. A different type, right, of billing for services not rendered is, billing for non-covered services as covered services. This happens when, often in context of, say, cosmetics, right? This is where you bill for a nose job, which is a cosmetic non-covered item, but you bill it as a deviated septum repair, right, which would be a covered surgery. Another example, right, might be billing a breast augmentation as, breast cancer removal, right? That's a non-covered services as covered services. Just to give another example, if you're billing, pedicures and massages as, physical therapy and chiropractic, right? That non-covered services as covered items. A variation on that, right, is upcoding, what we call upcoding. Upcoding is when you see a doctor, or a medical professional, and they bill for a higher level service of care than that which was actually provided, right? So say, for example, that you went in and you had a brief encounter with the doctor, non-invasive, non-exploratory, not a whole lot of physical contact. A quick office visit, right? That might be typically billed at what we call level 1 or a level 2, which is a lower cost, level quality, service encounter. But some healthcare providers, right, to build the system always at a level 4 or a level 5, which is the highest level service of care. Well, if you're consistently billing level 1, appointments as level 5, build them as level 5, that's billing, for different services than those actually provided. You're billing for services not rendered. Another scenario is what we call unbundling. This is really a double billing scenario where, certain services are wrapped into one billing code, where all of the component services are all grouped together in one line item. And sometimes what you'll see healthcare providers or collection, or billers do is they will both bill the grouped code, right, the bundled code, and then they will separately bill each of the, codes within the bundle individually, which is essentially a double billing practice. One of the last sort of, big picture area of traditional fraud, right, is the, billing for services, performance and billing for services that are, excluded under the plan, billing for services that are not medically necessary, experimental, or really in investigative nature. There is case law in many jurisdictions, including California, that says that if you can perform medically unnecessary services, but to bill those to an insurance company in and of itself, may constitute an act of fraud. So if you really talk about services not rendered, billing for services different than non-covered services as covered services, and really getting into these exclusionary issues, these lack of medical necessity issues, and certainly, the double billing, sort of items we've talked about, those are really the classic trends. So with that in mind, let's talk about how we've seen this applied, in COVID-19. COVID-19 testing, right? The first bullet point here, fake tests. So a classic scenario that we've seen during the COVID era, particularly earlier on, and you may have seen this, on the news or in the media, is this idea of fake tests. You would have just, people pretending to be healthcare providers and setting up fake sites, almost like drive-through sites where you could come in and get a COVID-19 test. And these, frankly, were fake. And what the, fraudsters were doing was they were trolling for cash, right? You pay them, $100 or $200, and they give you a test right then and there. That's a fake test. And really what they're trolling for is your PHI, right? Your private health information. That's your social security number, your name, your address, the name of your, benefits provider, your account number, your individual account number. And once, they take your cash, right? But then what they really do is take your PHI and then would submit, false claims to any number of insurers or healthcare plans. So fake tests was a big one, continues to be. Next issue is one of next bullet here is one of patient incentives, right? So I think, insurers, right, and payers should be on the lookout for any scams that they see where patients have been incentivized, perhaps to, knowingly or unknowingly, end up as part of a fraud. So, for example, we talked about copay waivers and coinsurance and deductibles. Those are an important part of the healthcare system, the insurance system. And if patients are being given free services or discounted services or waived copays, waived coinsurance, that should be a red flag. That perhaps what's really happening is that fraudulent providers are using they're incentivizing patients to come see them, so then they can then take the PHI and again submit false claims for payment. Next bullet, similar to patient incentives, right, is the idea of incentives from providers to labs or other downstream services. So, for example, in COVID-19, we're seeing kickbacks from labs to providers or telemedicine companies to order tests, right? And think about the cost of care and the cost of insurance, right? If the lab is paying kickbacks, right, to the providers, well, they're probably going to make that kickback back, so to speak, by raising the price that they're actually charging the insurers for the service. That's going to raise the cost of care, raise the cost of insurance premiums, and raises costs to the whole system. So I think insurers and payers would be wise to look out for any patterns or things they see or hear where there have been incentives within the provider community that may be illegal kickbacks. All right, next bullet, billing unlisted lab tests with COVID-19 tests. So early on in the COVID-19 era, prior to April 1, 2020, there was no billing code, right? No ICD-10 code for a COVID-19 test. So in those early weeks, the way this would be billed is usually you would see a bill for some sort of unlisted lab test, right, or a lab test that didn't have a specific code. But as of April 1st, right, we now do have a specific code for the COVID-19 test. But what we're seeing, right, is still multiple tests showing up on the bill. So it's usually the COVID-19 test, billing code, along with what they used to submit, as the unlisted lab test. And really, this is kind of like the unbundling, but it's really just double billing. So keep an eye out for unlisted lab tests being listed alongside the COVID-19 test. Last bullet here at the top, bundling or coupling, right, with unrelated tests. What we mean by this is, right, this is, again, the COVID-19 test with other tests, right, maybe something that is listed, but really a situation where a COVID-19 test is pretty simple, it's pretty efficient, it's relatively inexpensive, but what we're seeing is the COVID-19 test is being coupled or bundled along with, right, more expensive testing. One in particular, right, is this respiratory pathogen panel, which is a pretty expensive test. So, if you're seeing a COVID-19 test and a bunch of, ancillary or additional tests that are far more expensive, that's potentially a red flag. And it's particularly a red flag, right, if that COVID-19 test comes back negative. If the patient reported as asymptomatic, right, and they ultimately didn't have COVID-19, that may raise questions. Why were all these other, far more expensive, tests being done and billed for? So that's something to keep in mind. Another one is, allergy tests or, other sorts of tests that aren't necessarily tied with COVID-19. So you should be looking for things that are unrelated or, maybe related tests, but that are really expensive. So those are some of the trends we're seeing. Wanted to give you a quick example of a recent high-profile criminal case that's pending here in Northern California that really, puts these tests or these schemes sort of all in one package. We took the name out just for purposes of this presentation today, but this is what the complaint's about. So a criminal complaint was filed on June 8, 2020, alleging the president of a California Healthcare Technology Corporation. And the allegation is that the corporation committed securities fraud and conspired to commit healthcare fraud. The criminal complaint alleges that the corporation submitted $69 million in false claims for COVID-19 and allergy tests. The lawsuit alleges that the corporation claimed it could detect COVID-19 in dried blood samples and was telling clinics to bundle the test with its allergy diagnostics, right, regardless of need. The criminal complaint alleges that the president and the corporation paid kickbacks and bribes to recruiters and doctors to promote, these high-cost allergy tests. Ultimately, right, it led to the submission of false and fraudulent claims for an unrelated, far more expensive allergy test for up to 120 allergens, using, again, the PHI information obtained through the inexpensive COVID-19 test. So, I think we think that's a good example of sort of a bunch of the COVID-19 scams all wrapped in one fact pattern. In terms of, what can payers do, right? Should always be screening providers, running analytics, conducting audits, looking for red flags. Next slide, please. All right. Just to touch on a few additional COVID-19 fraud schemes. COVID-19 drugs, right? First and foremost, there is no vaccine to date for COVID-19. So if you are a insurer or a health plan and you are receiving billings that describe any sort of vaccine on the billing, that should be a big red flag, and you should be asking questions because there is no vaccine for COVID-19. Another one is unapproved treatments, right? Fairly high profile. There was one anti-malaria drug in particular was touted as perhaps a possible treatment for COVID-19. There are a host of whether I don't know, medicines or oils or creams or lotions or drugs that could be taken that if you're getting billed for those, I think this is a big red flag, and you should be having your medical experts look into whether there's anything about this treatment that actually treats COVID-19. So big issue is looking for unapproved treatments and certainly any billings that purport to be vaccines for COVID-19. Next bullet, counterfeit or unnecessary personal protective equipment and durable medical equipment. Think, sanitizers, gloves, face masks, thermometers. The costs of personal protective equipment and durable medical equipment, they can rack up quickly. So if you have patients coming in or that are being seen and then they're being bombarded with, PPE and DME, that's a red flag that should be looked at, particularly, right, if the patient that came in was asymptomatic or, had a negative COVID-19 test. I mean, what is it that they're really being seen for? And is this really just a scam to, distribute at very high cost and mark up, PPE and DME? In terms of, we mentioned counterfeit here. I should say, for example, right, there's one very large, Fortune, 100 company that makes, N95 masks, and those have been counterfeited all over the market and charged, at excessive prices. And, that maker, that manufacturer in particular has spent a lot of time and money, trying to protect its trademark, trying to get those, working with the government to try to get those counterfeit, masks off the street. All right, next one, billing for dates of service when clinics are closed. So, for example, right, there's the healthcare orders, right? There's a shutdown. So if you are getting bills from providers during, periods where, by state or county order, that clinic was closed, that's a big red flag. Next one, fraudulent bills for patients whose info has been obtained through trolling and phishing. Well, we talked about that previously on the previous slide. That's a lot, the fake tests and so on. Telehealth fraud, right? So telehealth services, presents opportunities, right, or issues and opportunities for fraud. So, several things to look for here, right? Again, sort of going back to the closure, right, the forced closure of business in March, April, May, and also a reluctance of people to go in and see doctors, in person. If you're an insurer or payer and you're receiving a high number of in-person office visits for March, April, May, June, that should be a big red flag, right? The clinics are supposed to be closed. The people presumably aren't wanting to go in and see a doctor. If you're getting an uptick in visits or frankly not a downtick in visits, that's something to look at. Another one, right, is billing for hands-on therapy. Certain services can be done by telehealth, but certain services, certainly don't work. If you're getting bills for chiropractic, or other care, right, that necessarily is done in an office setting, query whether that was really happening, right, during the period of shutdown. With telehealth, I think there's also a question of, what level of service was being provided, right? So if you're getting, a bunch of bills that come in, this sort of the upcoding issue that are billed at like level 5, were they really happening, or were these more telehealth visits, and maybe should those have been billed at a lower level of care? So telehealth presents, numerous issues. Again, just traditionally look at the spike in fraudulent claims for quick cash. People are stressed. This is an opportunity for, fraudulent claims to be presented, and be on the lookout for all those traditional schemes as well as the COVID-19 schemes, as a means to get quick cash. Staged accidents and related medical and auto, certainly people are driving less, but they're also not working. And this is an opportunity where you might see staged accidents rings. Kathy may talk a little bit more about that during the presentation. Last here, a spike in workers' compensation claims to avoid losing your job, and also false claims by employees to avoid having to go to work, right? These are issues in the COVID-19 era. So people don't want to lose their job. They may say that they're hurt or injured, or that they have COVID-19, or they say they have COVID-19 so they don't have to go to work. So those are a lot of the schemes we're seeing. I'm going to turn it over to Kathy. She may have a couple more comments, or if she'd like to provide any more color on fraud schemes, and also talk about insured claim handling strategies.
Thanks, John. So given all of these new types of fraud schemes that have emerged during the pandemic, and also the proliferation of more traditional types of fraud, which are likely to occur in environments like this that are ripe when people are stressed and strapped and times are not good, it is absolutely critical that insurers keep their eye on the ball and focus on strategies that are designed to detect fraud and to help them avoid paying fraudulent claims. The specific types of fraud schemes that John addressed, which have arisen during the pandemic, are really just subcategories of traditional types of fraud schemes. Like John said, you've got anything from billing for services not rendered to billing for services that are the result of illegal kickback arrangements. You've got staged accidents. These are all types of insurance fraud schemes that most people are familiar with. So as with traditional claim handling strategies that are focused on fraud detection, at a really high level, even during the pandemic, when you're trying to detect pandemic-related fraud schemes, insurers should be looking for anomalies in billing. That's really what insurers look for when they're looking for fraud. For example, you want to look for new providers that are popping up that suddenly have a high volume of claims. Maybe those are new labs that have never billed for anything before, and all of a sudden, they go from 0 to thousands in a day. That doesn't seem natural. That kind of situation would be a red flag, because in the normal course, a new provider would probably take some time to ramp up the claims volume. And there may be some type of improper reason that they're suddenly in a position to submit a high volume of claims, from the get-go. You also want to look for spikes in the volume of claims from providers that you already know. Maybe there's a legitimate reason for the spike in claims, but spikes in claims are when you see them, you definitely want to investigate further. So that's something at a high level you want to keep your eye out for. And likewise, you want to keep an eye on claims for new types of services and treatments that you're not familiar with, and probably need to dig a little deeper into those. You definitely want to look for situations, as you usually would, where providers are billing the same codes or services for most or all of their patients. You shouldn't see that in a legitimate patient population where services and treatments should be tailored to the unique needs of each patient. When you see situations like that and a provider is billing the same codes for virtually all of his or her patients, that's usually a red flag that they're billing for services that are not being rendered based on medical necessity, but are being rendered because it's financially beneficial to the provider. Keeping an eye on these types of billing anomalies will help insurers identify the more specific issues listed not only on this slide, but some of the fraud schemes that John talked about on the 2 slides before. And there are a series of steps that insurers should keep in mind when they're looking to identify claims that are the result of pandemic-related fraud schemes or any fraud schemes. And I'm just going to talk about them at a high level. I mean, we could spend days probably talking about each one of these, and we have a lot of ground still to cover getting to the whistleblower statute, so I'm going to try and breeze through them. But The first thing is to have a strategy to look for each specific type of fraud scheme. So you want to figure out what can we do to look for this type of scheme and then implement it. So you need to have a strategy. You're going to start then by mining the data to look for the types of billing anomalies that I went through. When you identify those billing anomalies, you're going to want to then dig a little bit deeper into the data. So if you see a new provider, who is the new provider? What are they billing for? What is that provider's background? For existing providers with billing spikes, what are they billing for? Are there any unusual patterns that you can discern? Like, are they always billing the same services for all of their patients? Or is it, a new provider and they're billing all different kinds of things that seem to make sense? For unusual or unlisted CPT codes, how often is that happening? If you see these unlisted CPT codes coming up, if a provider has billed for an unlisted CPT code once or just a handful of times, that might not be a concern. But if it's on virtually all of the claims, that could be a red flag. So, John talked about the situation where you have COVID tests being bundled with allergy tests or this respiratory test that's extremely expensive. If that happens one time, a couple of times, it seems like maybe that patient would need it. But if you're seeing that across an entire patient population, the alarm bells should be going off. Same type of analysis for providers who are billing for services during a stay-at-home order, when people are reluctant to go out unnecessarily. If it's a couple of dates of service, that probably makes sense. People need to see the doctor, but again, you wouldn't expect to see a super high volume of claims during that time. So, you want to be digging into the data. For kickback relationships with labs and providers, you may start by focusing on a single lab and then expand outward to see which doctors appear to be ordering the tests there if you've got a new lab. And if there's a lot of doctors, in an area, it might not be an issue. But if you see just one doctor or a small handful of doctors that are responsible for ordering tests from this new lab that you've never heard of before, you might want to question the nature of the relationship. Once you've dug into the data a little bit deeper, if you have more questions or if your suspicions are heightened, you need to move further on into looking at this. And you should turn at that point to medical records or other documentation if you're able to have it. Not every insurance company, depending on the type of insurance we're talking about, would have those records, but if you've got them, they can be a real helpful source of information. You want to look to see what the providers are saying that they're doing. You want to look for patterns in the medical records or the documentation that might not make sense. If you've got a telehealth situation and you've got doctors billing for a high volume of telehealth visits or even office visits, you want to look at those records together and see, are they all the same? Do they seem to be tailored and unique to each patient? Do they match sort of the level of services that are being billed? The documentation is important and you need to look at that. And after looking at the documentation and mining the data, you still have concerns. Definitely you need to think about bringing in a medical expert as part of your strategy and find out from the medical expert whether the services and bills make sense from a medical perspective. And then beyond that, if you're able to speak with insureds or even the provider or employees of the provider, that you could get helpful information there. And that is particularly true in situations involving billing for services not rendered or in situations involving kickback arrangements or financial incentives. It's not always possible to talk to people, but if you can, that's often helpful. John mentioned the staged accident rings. Sort of an interesting theme that has developed during the pandemic is that there has been an increase in staged accidents. And what's being reported and what I understand is that the reason for this is that, as John said, there are less people on the road, and of course people are, times are tough and so more likely to do this kind of thing, but it's, I guess, a little bit easier with less people out on the road to stage the accidents. And so there are traditional factors that you look for that are the classic red flags of staged accidents, multiple occupants in a vehicle, injured people who have had multiple claims with various insurance companies or who share the same address with others who were in other accidents, or if in a certain radius there's a high number of accidents with similar sort of bizarre explanations for the accident, like I reached down to grab a drink and that's when I got in the accident, and everybody has the same explanation, or if you're seeing these red flags come up and the injured people in the car accidents are going to the same healthcare providers, they have the same lawyers, the cars are going to the same auto body shops. These are all red flags, and insurance companies should just be aware that during this time there is an increase. Okay, on to the next slide. Now that we've talked about some of the types of fraud schemes that have emerged during the pandemic and how insurers can be working to identify and avoid paying fraudulent claims, we're going to talk about a very powerful way to address these types of fraud schemes. Two state whistleblower statutes in California and Illinois give insurance companies very powerful remedies. And that would include not only with regard to fraud schemes that are specific to the pandemic, which we have talked about, but also other forms of insurance fraud as well. Many of you are probably familiar or have heard of the Federal False Claims Act, which allows whistleblowers to file lawsuits on behalf of the federal government based on the submission of false or fraudulent claims to the federal government, which includes Medicare. So you hear a lot about False Claims Act lawsuits that are based on Medicare fraud. This map here shows that in addition to the False Claims Act, several states across the country have whistleblower statutes that protect other governmental programs, including Medicaid or state programs. But only two states, again, California and Illinois, have statutes that allow whistleblowers to file lawsuits alleging that false or fraudulent claims were presented to non-governmental payors, which would include all types of insurers, auto, health, workers' comp, as well as self-funded plans, which Brad will discuss in a little more detail later in the presentation. Next slide, please. So these two statutes, which we're going to focus on for the next portion of our presentation, are the California Insurance Frauds Prevention Act and the Illinois Insurance Claims Fraud Prevention Act. And under both of these statutes, private insurers and self-funded plans can act as whistleblowers to file lawsuits. The lawsuits are brought on behalf of the people of Illinois and California, and it's based on the presentation of false or fraudulent claims to the insurance companies themselves, as well as other insurers. And it's really a critical feature of these two statutes, which we'll talk about in a fair amount of detail today, that the whistleblowers are not filing the lawsuits on their own behalf. They're not trying to seek damages or recover damages for how they themselves were harmed. They're filing the lawsuits essentially as private attorney generals, and they are prosecuting fraud claims on behalf of the state. And although they're not seeking to recover their own damages, by bringing lawsuits under these statutes, the whistleblowers stand to collect significant amounts of money. The statutory penalties are $5,000 to $10,000 per fraudulent claim. It's the same under both the California and Illinois statutes, plus up to 3 times the amount of each fraudulent claim as well as attorney's fees. So when you're talking about fraud schemes involving hundreds or thousands of claims, the financial repercussions for the fraudsters add up really quickly, as does the recovery or potential recovery for the whistleblowers. And as you will see, these statutes give insurers a ton of leverage to litigate the claims. And the leverage is very intentional. The California and Illinois legislatures enacted these whistleblower statutes with the specific purpose of encouraging insurance companies to file lawsuits because it's in not only the public's interest to fight insurance fraud, but also the government's interest. And, you know, as is widely reported around the country, fraud costs the public millions and millions and millions and millions of dollars, and insurance companies have to increase premiums to offset the cost of fraud, and that hurts consumers. Fraud also results in patients being subjected to unnecessary treatment. They don't receive the treatment that they do need. And really just overall, as a result of insurance fraud, the trust in the healthcare system and the insurance system is eroded. So the California and Illinois legislatures, you know, took some very unique steps, but were very clear about why the statutes were enacted. Next slide, please. So the first three bullets on this slide, which addresses the purpose behind the California whistleblower law, cites language directly from the statute itself. It's California Insurance Code 1871.7. The language in the first three bullets there just discusses the scope of the problem, but it does so specifically in the problem obviously being insurance fraud in the context of auto, health, and workers' compensation insurance. So the statute is very, very, very clear about what it's designed to address. And over the last several years, there's been some really great case law in California that's been developed that picks up on this language and specifically says that the statute was intended to encourage insurers to bring fraud actions. We cited a couple cases here, but I really like the explanation in the Strathman case. It's the second to last bullet there, which says it is in the government's interest to have insurers investigate and prosecute such proceedings. The government serves to gain both in terms of fraud prevention and financially from such actions, especially given limited investigative and prosecutorial resources available to it. So the government's really looking to insurance companies to help with this problem, which impacts everyone. Next slide, please. The Illinois statute was enacted a little bit more recently than the California statute. It was in 2002, and it was enacted after a task force was created in Illinois to address insurance fraud schemes, and the task force recommended the adoption of a statute similar to California's IFPA. So the Illinois statute was modeled directly after the California statute, and as we talk about these key provisions in the statutes, you'll really see how similar they are to one another, but the purpose behind the Illinois whistleblower statute is the same as California's. They want to address insurance fraud, and they want to encourage insurers to bring these actions. Next slide, please. So as we talk about these statutes and how they work, one of the first questions that we need to ask and answer is who can file a lawsuit under these statutes, or from a legal perspective, who has standing? And the answer is that any interested person can act as a whistleblower under either of these statutes to file a lawsuit. We talked in a fair amount of detail about the public policy behind the statutes and why they were both enacted, so it should come as no surprise that insurance companies are absolutely considered interested parties, and the law is very clear on that. It's also important to understand who is not an interested person. To be an interested person under these statutes and to have standing to bring whistleblower actions under them, you need to be more than just a source of information, and you need to have more than just an interest in the ultimate recovery if you prevail in the lawsuit. And there are two recent cases in Illinois and California which address this particular issue. In the Feingold case from 2019, an Illinois appellate court held that the patient, who was the whistleblower there, did not have standing as an interested party under the statute because the patient did not allege knowledge of the fraud based on the patient's own experience with the defendants as an employee, direct customer, or insurance company. And similarly, in this STF case that we have cited here, the Northern District of California dismissed an IFPA claim because the whistleblower there did not allege that it had non-public information of possible wrongdoing. So the takeaway here is that to be an interested person, you need to have non-public information that you obtained based on your own experience. And an insurance company who receives, reviews, and makes decisions on claims is certainly considered interested. There's a little bit of a nuance when it comes to self-funded plans in California in particular. So I'm going to turn it over to Brad to talk about that issue in the next slide.
Thanks, Kathy. Yeah, as Kathy mentioned, self-insured plans often face a particular hurdle when it comes to these statutes because they, in California, for instance, the statute itself appears within the insurance code, and I think those of you that are familiar with ERISA and self-insured plans, the general knee-jerk reaction when it comes to insurance regulations at the state level is that they don't apply to ERISA plans. But the key here is that these statutes, these whistleblower statutes, are not regulating insurance. Indeed, they're regulating fraud, and they're meant to protect all payers against fraud, and that's precisely the purpose behind each of these laws. And they, we've actually had some conversations with folks at the California Department of Insurance who echo this and want these laws to be applied broadly to not just regulated insurance companies that are under the CDI's specific jurisdiction, but also to attack fraud that's being perpetrated against other types of payers, including self-insured plans, and indeed, consulted with them a number of occasions in which they've encouraged this kind of application, and have even intervened in a case in which we're representing a self-insured payer. So there was a challenge in this case that people of the state of California v. Amador, in which this very issue came up at the demur stage, the pleading stage of that issue, and the court really picked up on the two key points, which is that, as we've already talked about, the purpose of these laws is to be broad in their application to attack fraud, but also the definition of insurance under California, and we'll get to Illinois in a second. The definition of insurance company under California law is broad. It's simply the any contract whereby one party is indemnifying another against loss, and that applies if it's a regulated insurance company or if it's a self-insured plan, which is oftentimes a contract between employers and employees. Similarly, Illinois expansively defines insurance company, and one of the underlying statutes that is a predicate for the Illinois insurance fraud statute actually specifically mentions fraud against self-insured payers. So we're confident that these challenges will be met with the same kind of response that the court in California had, which is to say that, yes, these laws are broad enough to cover fraud against self-insured payers. And I'll turn it back to Kathy to talk about who can be sued under California and Illinois law.
And Brad, just before you turn it over to Kathy, just for the viewers, I wanted to provide the CLE code, and I'll give it again at the end of the presentation. But for those who need the CLE code, it's SS, as in Seyfarth Shaw, 1313. Again, that's SS, as in Seyfarth Shaw, 1313. Go ahead, Kathy.
Thanks. So we've talked about who can sue. The next question, naturally, is who can be sued. And the California and Illinois legislatures have made it possible to sue basically anyone engaged in almost any type of insurance fraud scheme you can think of. And the statutes, which are structured similarly to one another, divide the types of fraud schemes into essentially two categories, and to be liable under either of these statutes, a fraudster would just have to participate in one of them. So under the first category, any person who knowingly presents a false or fraudulent claim to an insurer is liable under the statutes. This language, the language of the statutes and the case law interpreting it, makes very clear that the statutes have a wide reach. So essentially, anyone who presents or causes to be presented a fraudulent claim to a payor is going to be liable. It would include the traditional types of fraud schemes that you can think of, claims for services not rendered, medically unnecessary services, claims for double billing, that type of thing. And indeed, in a recent case brought by State Farm, which alleges that claims submitted by an MRI brokering company were fraudulent, which is the People X Rel State Farm versus a Guy case we have cited there, the California Superior Court made clear that the statute encompasses virtually all types of insurance fraud when it held that a person can be sued for presenting claims, quote, characterized in any way by deceit. So really, really broad, and you can fit a lot in there. There's also specific case law explaining that sham medical practices that are owned or controlled by laypersons in violation of the bar on the corporate practice of medicine doctrine can be liable under the statute. That's the Monterey Mushrooms case. The statute also encompasses claims presented by sham law practices that are owned or operated by laypersons, which came up in an Allstate case, the Allstate versus Sue case. And that's particularly important in jurisdictions like California and Illinois, where, at least in the auto insurance context, law firms are often the ones presenting auto accident-related medical claims to insurers as part of demand packages. So if you have a sham law firm presenting the demand letters and the claims, that type of thing can happen with the staged accident rings. You might see that. That sham law firm and the people who are really owning and controlling it can be liable under the whistleblower statutes, and perhaps even if the services are themselves legitimate. Under the second category of schemes here, a person can be liable under the statutes if they pay someone to obtain patients or clients whose claims will be presented to an insurer. So in other words, a provider or a lawyer would be liable for paying someone to solicit patients or clients for them under the statutes. And under this second prong of the statutes, providers who pay kickbacks in exchange for patient referrals are liable. That was made clear in this advanced physicians case that we cited here, which is a 2018 Illinois appellate court case that says that insurers can bring civil actions on behalf of the state for insurance fraud, including kickback schemes. So that was very clear. And in California, it also came up in this Agai case I mentioned involving the MRI brokering scheme, where the MRI broker was actually a radiologist and had argued that as a doctor, he couldn't be considered a runner, capper, or steerer. That's the language that's used in the California statute. And the trial court rejected that argument and said the statute contains no exception from these terms for people with medical license. Next slide. So in the previous slide, I explained that anyone who presents or causes to be presented a fraudulent insurance claim is liable under that first category. I just want to give a little bit more detail about what that actually means and kind of what the operation of that is. Both the California and Illinois whistleblower statutes actually create private causes of action for violating state criminal laws related to insurance fraud. In California, the private cause of action is found in 1871.7b of the insurance code, and it says that if a person violates certain enumerated sections of the California Penal Code, they're liable under the whistleblower statute. And the three enumerated sections of the Penal Code are listed here. It's 549, 550, and 551. And just quickly, under 549, it's a crime to solicit, accept, or refer business to or from anyone knowing that the claim that will be presented is going to be fraudulent. Section 550 makes it unlawful to present or cause to be presented a false or fraudulent claim to an insurer. And under 551, it's unlawful for an auto repair dealer or its employees or agent to offer a fee or anything of value to an insurance agent, broker, or adjuster in exchange for referrals. So those are the three kind of predicate acts that someone can be liable for under the IFPA in California, and an insurance company can file a lawsuit, a civil cause of action to prosecute those claims. Illinois is structured very similarly to the California statute, and the second section here also creates a private cause of action for violating the Illinois Criminal Code, and it subjects violators to, same thing, civil penalties and assessments under the whistleblower statute. The key provision of the Illinois Criminal Code for our purposes of our discussion is 17-10.5, which makes it unlawful to commit insurance fraud on an insurance company or self-insured entity. So that's what Brad was referring to, that it expressly talks about self-insured entities, by making a false claim or causing one to be made. That's how those operate in terms of what you can sue for. Next question is, when does liability attach? This is an aspect of the statute that is extremely unique and gives insurer whistleblowers a significant amount of leverage and streamlines litigation for insurers. So as you may know, if an insurer was going to bring a more traditional cause of action against a fraudster, like for common law fraud or civil RICO, the insurer would need to show that a misrepresentation was made on a claim, that the insurer relied or reasonably relied on the misrepresentation, and that the insurer was damaged. And only then would a defendant be liable for fraud or for civil RICO violation. But under the California and Illinois whistleblower statutes, you don't have to prove either reliance or damages, which is hugely important. Instead, a fraudster becomes liable once the claim is presented to the insurer. And this is really important for several reasons. First of all, it becomes irrelevant whether the claim was actually paid. So if a fraudulent claim is presented to an insurer and the insurer recognizes it's fraudulent and denies it, that claim can still be a basis for liability under the whistleblower statutes. Second of all, since reliance is not an element under these statutes, and it doesn't matter whether the insurer was actually duped by the claim, whether the insurer paid the claim, didn't pay the claim, claim handling becomes irrelevant. And this aspect of the statute has the effect of significantly streamlining discovery. An insurer whistleblower may be able to avoid producing entire claim files, particularly if there are no statute of limitations questions about when the insurer learned of the fraud. That can save insurers a huge amount of money on document reviews and document productions. For example, you might be able to just produce the demand letter with the supporting documentation from each file where a fraudulent claim was presented by the defendant. And you also don't have to get into any issues which can sometimes get messy relating to claim handling. You know, claim handling is not always consistent, particularly in large enterprises. So that's very beneficial to insurance companies. Not having to prove damages is also a huge benefit to insurers, and that's particularly true in these two jurisdictions of Illinois and California. Again, at least in the auto context, where insurance companies are often, just called upon to pay lump sum settlements to injured parties, and the lump sum settlements could include payments for services from multiple providers, not all of which may be fraudulent. And when you have to prove damages in those situations, it can get really tricky to parse out what portion of the settlement was intended to cover the allegedly fraudulent bills. And under these whistleblower statutes, you just don't have to do that at all because the defendants are liable for statutory penalties and assessments. The next aspect of the statutes that gives insurers a tremendous amount of leverage has to do with the scope of the claims at issue. Unlike traditional fraud cases where insurers can only recover damages for the fraudulent claims that they paid, under the Illinois and California statutes, insurance companies can take discovery on and obtain the statutory penalties and assessments for fraudulent claims presented to any insurer as part of the fraud scheme. And the reason for this is that, as we discussed earlier, insurance companies are not filing these lawsuits on their own behalf to recover their own damages. Instead, the insurer whistleblowers are filing these lawsuits on behalf of the people of the state of California or Illinois. They're acting as a private attorney general, and they're therefore permitted to prosecute the entire scope of the scheme, regardless of which insurer received the fraudulent claims. As you can imagine, this aspect of the statute gives the whistleblowers a ton of leverage. The defendants are going to be required, if asked to do so, to produce claims submitted to any insurer. Not only does that take a lot of resources for the defendant, but the resulting document production can be really, really helpful to the whistleblower. The more fraudulent claims the whistleblower can uncover that look similar to one another, the more likely it is that the claims were intentionally fraudulent and not just a mistake. The documents can help prove intent and motive because they will hopefully show the full financial scope of the fraud scheme and how much the defendant stood to collect from all insurance companies, not just one. And really importantly, by driving up the number of claims that are at issue in the lawsuit, the potential liability of the defendants and the amount the whistleblower stands to recover can go up dramatically. As you can see here, and as we mentioned, the remedies are $5,000 to $10,000 per false or fraudulent claim. That's the statutory penalty, plus an assessment of up to 3 times the charge for the false claim. So just to give a quick example before I turn this over to Brad, if the whistleblower insurer, the one who filed the lawsuit, received 100 fraudulent claims, and each of them was for $1,000, and they filed a lawsuit. But after discovery, they learned that actually, if you look at all of the insurance companies, there were really 1,000 fraudulent claims presented. Suddenly, the maximum recovery goes up from $1.3 million plus attorney's fees, and that's if you assume the high end of $10,000 per fraudulent claim plus the full treble assessments of $3,000. So that would be $13,000 times 100. It goes up to $13 million plus attorney's fees. And just up until recently, that aspect of the statute had been relatively underused, but there's been some really helpful case law developed over the last couple of years, including in this Agai case that I've been talking about, and it gives the insurance companies a lot of leverage, and it's a really important aspect. I'm going to turn it over to Brad now.
Great, thanks, Kathy. And I want to be conscious that we're over our hour at this point. We still have some ground to cover. But John, can you mention the CLE code one more time for those folks that can't stick around?
Sure, we'll do. It's Seyfarth, SS, as in Seyfarth Shaw, 1313, SS, 1313. And just also a reminder that this is being the audio is being recorded and will be available to all the listeners and others later on Seyfarth.com. Go ahead, Brad.
Great, thanks. Yeah, and just to underscore another point of what Kathy made, so this can, not only does this apply in situations where there are multiple insurers that might have been defrauded, but those multipliers really add up in cases where there may be relatively low dollar claims, where oftentimes it's not worth the payer's time to spend a lot of time investigating or pursuing fraudulent claims, like for instance in the chiropractic space, where things are relatively low. But when they add up and you get thousands of claims from one provider, each of those claims becomes actionable, whether or not paid, and actionable to the tune of, like Kathy said, $5,000 to $10,000. So, we've been involved in another situation where there was a chiropractic office that was submitting fraudulent claims, relatively low dollars paid. However, it resulted in an 8-figure judgment against that chiropractor that, like Kathy said earlier, provides a lot of leverage and a heavy hammer that insurers, self-insured plans can use to create a deterrent against fraud and really a sentinel effect in the market that doesn't just necessarily recover dollars against that one provider, but deters fraud by others as well. So I want to discuss briefly how these proceeds are paid out. So it works basically the same in both jurisdictions, that the attorney's fees are paid first. So out of any dollars collected, attorney's fees first get paid by the whistleblower and then by the government, if the government in fact intervenes. Then also the damages then to the whistleblower, if the whistleblower is in fact the victim of the fraud, those are paid. But after that, the dollars are divided either according to a stipulation that's been entered into between the government and the whistleblower, or depending on whether the government intervened, the whistleblower can get no cap in Illinois if the government did not intervene, or it's capped at 40%, and in California, it's between 30 and 40% if the government intervened, and a cap of 50 if they didn't. So that leads to kind of discussion of the pros and cons of the government intervention, which can be a longer discussion, and like I said, we're over. But I do want to mention this, that the government can add some benefits, right? If they intervene early, they can help with investigative strategies. They can, bring the full weight of the state government. They can often be an indicator to courts of the seriousness of the action. But on the other hand, sometimes, the government can take over the strategy of the case and can sometimes drag on. So it's important kind of at the early stages, as John will get into the procedural considerations, that, you make a consideration of how valuable the government's assistance will be. Quickly, we'll touch on a couple unique issues to self-insured plans. Self-insured plans oftentimes don't have the same level of protections against fraud that either insurance companies have, or certainly governments do. The federal government has the weight of the Department of Justice behind it, bringing actions against fraudulent healthcare providers, and insurance companies often have special investigative units, whereas self-insured plans are often, looking to third parties to do the administration, and don't often have all of the same level of protections. And these two statutes that we're talking about today actually are a protection in themselves, and wanted to highlight that. In terms of the discovery and investigation that go on, the self-insured plans often are faced with challenges because that investigation has been, and so because of those investigations being outsourced, it can be difficult to get some of the information that's necessary to file the complaint. And that's where the government can actually be of assistance. If the government intervenes, they can assist with the investigation. Earlier, I touched on the fact that there's been challenges to self-insured payers as to whether they can be victims of the fraud that's protected by these statutes are designed to protect against. And that may be a reason that you would want to file other causes of action, certainly before, until you get past the pleading stage. And as Kathy mentioned, those can bring some challenges because of the discovery fights that they often lead to. So it's an early consideration that a self-insured payer would want to bring. before doing this. So now I'm going to turn it over to John to discuss some procedural issues and wrap us up.
Thank you, Brad. And I appreciate the discussion on the unique issues of self-insured ERISA plans, because those are very important. All right, just to wrap us up today, we're going to talk about the procedural issues, because these statutes, again, they're unique, and the procedure is a little different. First and foremost, the statute of limitations, which is the same under both the California statute and the Illinois statute. And it's essentially this. The statute of limitations is 3 years after discovery of facts constituting grounds for commencing the action, but not more than 8 years after the commission of an act constituting a violation. And again, we've got statutory cites there. So just what does that mean, right? Today, it's September 2020. We can go all the way back for any, fraud that we discovered, at or after September 2017, for fraud dating all the way back to 2012. I mean, that's essentially where we are now, right? You've got to bring the action within 3 years of discovering the fraud. That's essentially akin to, what you see in state law, the delayed discovery rule. But we have to have a cap at some point, right? We can't go back after billings, in perpetuity forever. So essentially we have a hard cap, at 8 years. So again, 3 years after discovery of the fact and no more than 8 years after the violation. All right. When you file a lawsuit under these whistleblower anti-fraud consumer protection statutes, you file the complaint under seal, right? It's not publicly available. You actually serve the government, you file it under seal in court. You serve the appropriate government agencies, right, whether it's the Department of Insurance or the prosecuting government authority with the relevant evidence, the complaint, any additional information that they request. Who you do not serve, right, is also important. It's you don't serve the defendant, right? Again, this is under seal, and you're providing it to the court and the government without knowledge to the defendant. The government agencies then have, per statute, 60 days to investigate and decide whether or not the government wishes to intervene. In practice, the government will usually come back to you and ask for additional extensions, and often multiple additional extensions of time. More often than not, it will not be resolved in the first, at least in our experience, or my experience, not within the first 60 days. Ultimately, right, the government has choices. It can intervene or it can choose not to intervene. If the government does not intervene, right, the whistleblower proceeds and prosecutes the litigation. In California, the whistleblower must serve the government with a settlement agreement. There's no, at least 10 days before moving to allocate the settlement disbursement. Note there's no similar requirement in Illinois. All right, so if the government does not intervene, the whistleblower prosecutes the action. If the government chooses to intervene, the government decides the extent of its involvement in its role and how it wants to handle the case, right? It can intervene for purposes of dismissing the suit. It can intervene for purposes of trying to settle the dispute, or it can intervene and then go forward and try to litigate it to its conclusion. So again, if the government intervenes, it has control over the prosecution of the action. Question that sometimes people ask is, is there a right to a jury trial? And you can see from the bullets here, California, yes, in Illinois, no, and essentially that's that. We know that we are over today, so we wanted to thank you all for your time. If there are questions, we will review any questions that have been submitted, and we will get back to you, have someone get back to you with answers. On behalf of all of us and on behalf of our firm, we thank you for your time today. And that concludes today's presentation as part of Seyfarth's post-pandemic litigation series. Thank you.